All right. Well, thank you everyone for joining us today. We're going to go ahead and get started with today's webinar on New York City's private employer vaccine mandate and give you the 101 on everything you need to know on that mandate, as well as the New York State HERO Act and some additional information about New York State's current mask mandate. So just to begin, I'll introduce myself quickly. My name's Dan Deacon. I'm an associate here at the firm Conmaciel Carey LLP. I work in our Washington, D.C. office in the Workplace Safety Practice Group and the Labor and Employment Group. I've been with the firm for about 7.5, close to 8 years now, and I represent employers during OSHA inspections, both federal and state OSHA inspections and investigation, and handle the full array of litigation as it relates to those matters. I also represent and advise employers in all aspects of the employer-employee relationship on the wage and hour side. So jumping into today's agenda, and we're going to keep moving at a pretty good pace here because there is a lot of material to get through. And if you have any questions throughout the presentation, please feel free to put those in the chat, and I'll do my best to answer them on the fly. If not, I'll try and address those at the end, and you're always free to reach out to me at the end of the presentation afterwards with any questions. I'll provide my contact information and email. So you can do that. Moving on to the agenda here, like I said, we have a host of different topics that we're going to be covering. Notably, the first one that you see on the screen here, New York City's private employer vaccine mandate. We're going to go through everything that you need to know, the background, the key requirements. We're going to review some of the key frequently asked questions that New York City has posted on their website, the record keeping requirements, and some compliance tips for you moving forward. We're also going to dive in a little bit to the enforcement posture that New York City is taking as it relates to this mandate, and an update on the legal challenge that was filed just about a week and a half ago. And then we're going to transition and talk a little bit about the New York State HERO Act and what that act requires of employers, including the written program requirement and what you need to do if your employees request to form a safety committee and who that requirement applies to. And then finally, we'll touch a little bit on the current status of New York State's mask mandate. All right, so starting with the New York City private employer vaccine mandate, I'm sure as all of you know, last Thursday, the Supreme Court decided to uphold the stay of federal OSHA's vaccine or test emergency temporary standard. We're not here to talk about that in detail here today. We're talking about New York City's private employer vaccine mandate, which is certainly the most aggressive or I should say progressive in the country. So what is it? Well, the vaccine mandate was issued by the Commissioner of Health on December 13th, 2021. And what it requires is by December 27th, 2021, that workers provide proof of vaccination against COVID-19 to a covered entity before entering the workplace. And those covered entities need to exclude from the workplace any worker who has not provided such proof unless they are provided an accommodation for a disability or sincerely held religious belief. And really what we need to do is break down, when we're talking about who's covered, we need to break down some of these definitions. So what is a workplace? Well, that means any location, including a vehicle, where work is performed in the presence of another worker or member of the public. And this does include outdoor workspaces. So again, what businesses are covered by the order? We need to dive into these definitions. What is a covered entity, right? That's probably one of the big questions that you had from the last slide. Well, a covered entity is a non-governmental entity that employs more than one worker in New York City or maintains a workplace in New York City, or a self-employed individual or a solo practitioner who works at a workplace or interacts with workers or the public in the course of their business. So really this vaccine mandate covers almost all private employers in New York City. It's estimated to encapsulate over 180,000 businesses. So this is a very sweeping, broad vaccine mandate. And then the last definition that we need to dive into is, what is a worker? Well, a worker means an individual who works in person in New York City at a workplace. That includes all full or part-time staff members, employers, employees, interns, volunteers, or contractors of a covered entity, as well as a self-employed individual or a solo practitioner. But there are some specific carve-outs for what a worker does not include. And that's an individual who works from their home and whose employment doesn't involve interacting in person with any coworkers or any member of the public. So that is a truly remote employee, someone that is working directly from the confines of their home, and they have no reason or they'll never be in an office setting or interacting with any members of the public. It does not apply to workers who enter the workplace for a quick or limited purpose. And we're going to talk about what that quick or limited purpose definition is. There's some examples of that in New York City's FAQs, and that's really to make a delivery, to go to the bathroom, something where you're only going to be entering the workplace for a quick, de minimis amount of time. And worker does not include any non-city residents who are performing artists, college or professional athletes, or individuals accompanying such performing artists or athletes who don't have to display any proof of vaccination pursuant to the Key to New York City program or Executive Order 316. So moving on to what businesses are not covered by the order. So the order that was issued by the health commissioner specifically spells out a couple businesses that are not covered, right? And that is specifically those covered entities or individuals who are already subject to another order of the commissioner or the department, board of health, the mayor, or the state or federal entity that requires them to maintain or provide proof of full vaccination, or to those individuals, of course, that have been granted a reasonable accommodation. So a couple examples of that, right, would be if you're an employer that's covered by the CMS rule. That was one of the rules that was recently upheld by the Supreme Court just last week, or Mayor de Blasio's Executive Order 317, and that applies to employers that operate indoor entertainment and recreational settings, in certain event and meeting spaces, indoor food services, restaurants, right? And then the indoor gym and fitness settings. There's a few additional requirements under Executive Order 317 that don't apply to the broader private employer vaccine mandate that we're talking about here. And then finally, I mentioned this a couple slides ago, but there is no blanket exception for workers based on their industry or job duties. So this is all encompassing. If you are a covered entity, you are expected and required to comply with this vaccine mandate. And as I mentioned before, that includes workspaces that are outdoors. So I mentioned that covered entities need to collect vaccination, proof of vaccination of their workers, right? And what does proof of vaccination mean? That's the next question and the next definition that we need to dive into. So it means one of the following documents demonstrating that an individual has been, 1, fully vaccinated, or 2, received at least a single dose of the COVID-19 vaccine, or 3, received the first dose of a 2-dose COVID-19 vaccine regimen. And the documents that employees, workers can provide to you as acceptable proof of vaccination are the CDC COVID-19 vaccination record card or some other official immunization record from the jurisdiction, city, state, or country where the vaccine was administered, for example, local health department. 2, the New York City COVID Safe app showing their vaccination record. 3, a valid New York State Excelsior Pass or the Excelsior Pass Plus. 4, a Clear Health Pass, or 5, any other method specified by the commissioner as sufficient to demonstrate proof of vaccination. But really, we're talking about the first 4 when it comes to proof of vaccination at this point, as nothing else has been, no further information that's provided by the commissioner at this point. So you do need to maintain records of the worker's proof of vaccination. You need to maintain a copy, and I should back up one step here. There's a couple different ways that you can maintain those records, right? And you see all 3 on the screen here. 1, you can maintain a copy of each worker's proof of vaccination, and if applicable, a record of any reasonable accommodation that is provided to an employee, or you maintain a record of such proof of vaccination provided that that record that you're creating has the worker's name, whether they're fully vaccinated. For an employee that submits proof of only their first dose of a 2-dose vaccine, you should be monitoring, and you're required to monitor the date by which proof of the second dose needs to be provided. And that needs to be provided no later than 45 days after the proof of the first dose was submitted. And we're going to talk about that in a little bit more detail in a couple slides here. And then for a worker who does not submit proof of COVID-19 vaccination because they have been granted a reasonable accommodation, whatever record that you're creating to reflect this proof of vaccination, if you're creating a roster, right, you need to separately maintain records stating the basis for such an accommodation and any supporting documentation provided by that worker. And we're going to talk about the record keeping requirements when it comes to reasonable accommodations in a few slides as well. And then finally, you as an employer can also simply check the proof of vaccination before allowing that worker to enter the workplace on a daily basis, if you would like, and maintain a record of that verification. That might not be the easiest way of going about maintaining these proof of vaccination records, but that is one of the options that New York City has outlined in the order. For the December 27th deadline, right, the order was issued December 13th, and they gave employers or covered entities, I should say, in New York City, 14 days. They gave you 2 weeks to comply with this order. And there was a lot of questions about how's this going to be enforced, what's the enforcement posture, how are we remotely going to come close to complying with this within that deadline. And there was also questions about whether the mayor-elect, Eric Adams, was even going to keep this vaccine mandate on the books. And it came out just before the new year that he announced he was intending to enforce this vaccine mandate. He was going to keep it on the books, and it was going to be part of his program going forward to keep New York City safe. So the order itself only required employees to have received a single dose of a 2-dose vaccine regimen by December 27th. And those employees could continue and may continue working as long as they receive the second dose within 45 days of that first dose. So if a worker received the first dose of a 2-dose vaccine regimen more than 45 days ago and hasn't received their second dose, they're technically supposed to be excluded from the workplace at this time until they do receive that second dose or submit a request for a reasonable accommodation from having to get that second dose. So the CDC, obviously, the vaccine regimens, when we're talking about the 2-dose vaccines for Pfizer and Moderna, there's certain timelines, right, in which you're supposed to get that second dose, either 3 weeks or 4 weeks, depending on which vaccine you get. But the CDC guidance, right, it does recommend that's 3 or 4 week interval periods if possible. But New York City has clarified that a person who receives their second dose at any time after the recommended date doesn't have to restart that vaccine series. So even if that employee receives their second dose 50 or 60 days after their first dose, they can return to the workplace. So reasonable accommodations, right? This is a question that we as attorneys have been getting a lot of questions about from our clients, how to handle reasonable accommodation requests. So if an employee does come to you and requests a reasonable accommodation, you can continue to allow those employees to enter the workplace and continue working while their reasonable accommodation request is pending. In other words, you don't need to exclude that employee just because they haven't received the vaccine or received or otherwise been granted an accommodation at that point. So those employees can continue working at this time. So if any of your workers do not get vaccinated because you approved a reasonable accommodation for them based on a sincerely held religious belief or a medical condition or a disability, you need to maintain certain records. And what you see on the screen here is exactly what you need. And this is outlined in New York City's FAQs, but it's also the standard recommended ADA practice when we're talking about requests for reasonable accommodation. So you want to include when you granted the reasonable accommodation, the basis for doing so, and any supporting documents the worker provided for the reasonable accommodation. And really any documentation that documents that interactive process that you have with the employee talking about that reasonable accommodation and what it might be. So what can a reasonable accommodation be under these circumstances? New York City has provided some guidance on accommodations for workers that includes the EEOC factors on what constitutes an undue hardship. If you as an employer would experience an undue hardship, obviously you do not have to provide a reasonable accommodation. I'll caution that this is a fact-intensive inquiry, and there shouldn't be a bright line rule for each and every employee that comes to you requesting a reasonable accommodation. You do need to evaluate it on a fact and a fact-specific analysis, and then analyze it on a case-by-case basis. So New York City's reasonable accommodation guidance includes a checklist to help employers through that reasonable accommodation request process. And it lists the following potential results of an accommodation request. First being weekly PCR testing for COVID-19 and masking at all times in the workplace when an employee is not otherwise eating or drinking. Another option is telework or remote work that doesn't expose others to the accommodated worker. 3, a leave of absence. 4, no accommodation is granted because the unvaccinated worker would likely pose a direct threat to themselves or others. And then finally, no accommodation would be granted because the accommodation presents an undue burden on the employer. And again, that is a fact-specific analysis that you should be doing on a case-by-case basis. So the New York City guidance also has some additional information on how you as an employer should handle all the documents that you need to maintain. You should be collecting and storing those documents in a secure manner to ensure the privacy and security of the information is protected. This is considered medical records and information, so you do want to make sure that this is kept confidential and in a secure location that's only accessible by those individuals that have a legitimate need to access it for purpose of compliance with the order and enforcement within the workplace, or any other governmental orders, laws, or regulations. And obviously, if there were ever an inspection that were to occur at your workplace, for example, if the health department shows up and is requesting documentation and information related to your compliance with this order, that could be shared. But otherwise, this vaccination information should not be used for any other purpose, including the request for reasonable accommodations. So now I want to talk a little bit about remote employees, because this is one topic that was getting a lot of attention and that we've received some questions from existing clients about recently. So as I mentioned a little bit before, at the start of this presentation, a worker, the definition of worker does not include an individual who works from their own home and whose employment doesn't involve interaction with any coworkers or members of the public, or they ever come to the office at all, except for a quick and limited purpose. So if these employees are in the office beyond a quick and limited purpose, for example, if they're coming in to the office, I wouldn't say regularly, but even if they come into the office once a month for an hour or two meeting, they're still covered by this order, and they would be required to be vaccinated unless they do receive a reasonable accommodation. And there's examples of a quick and limited purpose, right? It's not coming in for those 1 or 2 hour meetings on an infrequent basis. It's examples of that you see on the screen here. It's using the bathroom really quick, or making a delivery, clocking in and receiving the assignment before you head out for the day to begin a solitary assignment, right? The next topic is multi-employer work sites, and we're talking here about contractors and your non-employee workers. So these non-employee workers, they are covered by the rule, and you as an employer, right, if you have perhaps employees from a staffing agency or your general contractor and you work with subcontractors, you do need to confirm proof of vaccination. However, for those contractors or non-employee workers, you only need to request that those workers, their employer, confirm that the proof of vaccination has been done. So you don't need to collect and verify for each non-employee worker. You don't need to verify their vaccination status individually. You can put that onus on the subcontractor or the employer of those non-employee workers, but you do need to maintain a record of that request to the contractor and the contractor's confirmation that they are in fact in compliance with the order. Otherwise, you can't allow those non-employee workers into your work site. And then there's this attestation requirement, and here we're getting to the end of kind of the rubric of what the rule requires, right? No later than December 27th, 2021. Obviously, that date has passed, but if you haven't done so yet, you're going to want to make sure that you are taking steps to comply with this rule. And one of the ways in which New York City expects you to declare that to the public and to all of your employees is by posting this attestation form in the workplace. So you need to affirm on this form that you see on the slide here. It's provided by the department. It's affirming compliance with the requirements of the commissioner's order, and it just needs to be posted in a conspicuous place in the workplace. From an enforcement perspective, right, this is kind of the elephant in the room. How are they going to enforce this, and what are we going to do moving forward? Because we as employers didn't get a lot of time to come into compliance with this rule, right? We were given 2 weeks notice to come into compliance by that December 27th date. And you know, it's not feasible for many employers to meet that date or meet a date that is even perhaps a month later. We're talking mid-January at this point, late January, and it's still perhaps a large undertaking for an employer to, especially large employers, to satisfy all the requirements of this rule. So inspectors from various agencies did begin enforcing the order on December 27th, 2021. They're using inspectors from all different types of agencies within the city and kind of deputizing them to go around and inspect for compliance with this order. And we did receive word from many retail employers. They did receive a visit from health department officials prior to that December 27th effective date, informing them about the rule and noting that there would be a return visit in early 2022 to evaluate compliance. So they are taking it serious, and they are going to be stopping into covered entities and checking in on their compliance with this rule. But from the question of, are we going to be shut down? Are we going to receive these big fines and escalating penalties for non-compliance? So there is a penalty provision, right? You may be subject to a fine of $1,000 for non-compliance and escalating penalties thereafter if violations persist. The new mayor, Eric Adams, however, indicated that the goal is really to educate employers and work with businesses to help them achieve compliance and not really to penalize them. So we anticipate that there will be a little bit of leeway to allow employers some additional time in coming into compliance with the rule. However, that doesn't mean that you can completely ignore the requirements of the rule. It's wise to at least take steps and make sure that you're collecting this vaccination information, getting notice out to employees of the requirement and what is expected of them and why, right? Because of this New York City private employer vaccine mandate, that is what they're required to do, or otherwise they can't be allowed to continue working in the workplace, of course, unless they receive a reasonable accommodation. So again, there is going to be some flexibility in the interim here in the short term, but at the end of the day, if you continue to allow unvaccinated employees in the workplace moving forward and don't take steps to comply with the rule, there will be penalties and escalating penalties thereafter. So the legal challenge aspect of this, right? There's been a host of different rules, federal and state, that have undergone legal challenges over the past year and a half, right? And it was only a matter of time before this vaccine mandate was challenged in court as well. And it was just a couple weeks ago. A Staten Island real estate firm filed a lawsuit in the Eastern District of New York, attempting to strike down the city's mandate. And the judge actually denied their request for a temporary restraining order just over a week ago on January 10th, 2022. And they found that the plaintiff was unlikely to succeed on the merits, and the balance of equities and the public interest weighed in favor of the city. And as of yesterday, the case was voluntarily dismissed without prejudice. So we do have one case that you see on the screen here that has challenged this vaccine mandate, and it was unsuccessful. So the vaccine mandate is still currently on the books, and I don't know of any other legal challenges that have been filed to date. That's not to say that they won't be forthcoming in the coming weeks here. So, all right. So now we'll move on to the New York State HERO Act, and let me just take a quick look at some of the questions that have come in and see if I can answer a few of these for you before we dive into the New York State HERO Act. Okay, so we have one question about, do new hires need to be fully vaccinated, or can they be hired after having one dose and then have 45 days to get the second? That is a good question. I would have to take a closer look at the FAQs on that. It was technically, you were required to have one dose by December 27th and a second dose within 45 days thereafter. I think moving forward right now, and given the leeway that New York City should be giving employers, and that they've announced that they will be giving employers for new hires, that they do have one dose of a two-dose regimen, I think that would be sufficient, as long as, again, you keep track of the date in which they need to receive that second dose, and they do so within 45 days. All right. So we have one question here about preemption issues. So, for instance, if you are, right, the New York City private vaccine mandate does spell out specifically what employers, what covered entities may not be subject to this vaccine mandate. And if you are subject to an existing and a rule that is in effect by a state or a federal entity, that those rules apply, right? So if you are an employer that's subject to the CMS rule, that rule applies, and you are not subject to the New York State or New York City private vaccine mandate. There isn't any issue on that front. The goal, right, is that those rules are very similar in that it does require employees to be vaccinated. So there's no concern there, and the vaccine mandate, the New York City vaccine mandate specifically spells that out. So you would follow the CMS rule, for example, or if you're an employer subject to Executive Order 317, right, if you're a restaurant owner, then you would comply with that existing rule. All right, so now we'll dive into the New York State HERO Act, and this is something that's been on the books for quite a while now. Governor Cuomo signed the HERO Act back on May 10th, 2021, and the New York State Department of Labor issued the standards to the HERO Act several months later on July 27th, 2021. So there were a lot of states issuing COVID-19 specific laws in 2021, but it's really important that you all understand that the HERO Act goes even further than a lot of those other state laws, because it addresses any and all airborne infectious diseases, not just COVID-19. However, it is kind of and I like to use the analogy of it's like the emergency mask that you have in the airplane. You're only allowed to use it, and it's only in effect when the pilot says so. Well, it's very similar here. The HERO Act standards and its requirements really are only in effect when the Commissioner of Health designates an airborne infectious agent or disease as a highly contagious communicable disease that presents a serious risk of harm to the public health. So there are certain requirements from the HERO Act that you do need to comply with at all times, right? You have to have a written program in place that can be activated at any time when the commissioner makes that designation, but otherwise the requirements, right, of what you need to do as it relates to workplace controls, pre-health screening, and we're going to dive into these in a couple of slides here, those don't need to be in effect. And interestingly, it took a while for the Commissioner of Health to designate COVID-19 as a infectious agent that's highly contagious and poses a risk to the public health. There was, as you can see, a good, 2-month delay, almost a month and a half delay since those standards were issued, and between that period of time and when the Commissioner of Health designated COVID-19 on September 6, 2021. And as time has gone on, that designation has been updated periodically. The most recent designation was extended on January 15th, 2022. And it basically, they've been doing this every month. So they go back at the end of that 30-day period, review the rate of transmission, and make an evaluation of whether that designation is still required, or whether they think it is a good idea to extend that designation. And since September 6, 2021, COVID-19 has continued to be designated as such. So what are you required to do as an employer? So there's 2 sections of the New York State HERO Act. Section 1, that requires all employers, regardless of your size. So it's employers of any size, they're required to create a written prevention plan of safety and health standards to protect employees from workplace exposure to airborne infectious diseases. And the New York Department of Labor and the New York Department of Health, they have published standards and industry-specific models on their website that you can all go and look at. They have template plans for you to model to the extent that you don't have a written infectious disease plan or a COVID-19 plan in effect yet. Those are a good starting point. So as it relates to what needs to be in that written airborne infectious disease control plan, it's everything that you see on the screen here. The topics that need to be included in your written plan include employee health screenings. That's one of the requirements. Make sure that you're doing pre-employee or employee pre-screening before they come into the workplace. Face covering requirement, personal protective equipment to the extent it's necessary, workplace hygiene stations, for example, that really just covers areas to wash your hands, or sanitizer stations. You need to have specific protocols for regular cleaning and disinfecting of shared equipment and surfaces. You want to make sure that you have included in that written policy the most recent quarantine guidelines in case of exposure, and any isolation requirements that may be applicable to whatever that airborne infectious disease is. Right now, of course, we're just talking about COVID-19, but again, you need to have this plan kind of in your back pocket in the future still. If COVID-19 goes away or the designation is lifted, you're still required to have this written control plan stored away, posted in the workplace, and it is there until the HERO Act is otherwise rescinded, right? You want to address compliance with any applicable engineering requirements or workplace practices. So that's anything that's related to airflow, exhaust requirements, your social distancing, compliance with any other local laws. And finally, you want to make sure that you have the appointment of the appropriate supervisory employees to maintain enforcement of those requirements of your written plan. There is a verbal review requirement whenever that designation is made. You need to provide a verbal review of what this written control policy contains with your employees. And best practice, of course, is to document that and make sure that you have some sort of training record that you did, in fact, review this plan with your employees. There's also a few additional requirements about the distribution and posting of the written plan in the workplace. So it does need to be provided to all current employees within 30 days of adoption of the plan, or within 15 days after reopening after a period of closure. And anytime a new hire is brought on board, you need to provide it to them upon hire. The plan itself does need to be included in the employee handbook. That's not to say that you need to include the 10 or 12 page written airborne infectious disease plan as a separate policy in your handbook. It could be an appendix, it could be linked in the handbook, but it does need to be in a visible location within that employee handbook, so employees do have a reference of where they can access it. It also needs to be posted in a visible location in the workplace itself. So we typically advise that you post that in the same location where you would post the employee rights poster or any citations that you may have received, just the area where employee notices are typically posted. And again, the verbal review piece. So whenever the Commissioner of Health does designate a disease as an airborne infectious disease that presents a serious risk of harm to the public, you need to provide that verbal review of the plan and what your policies are, because it may change, right? The intent of the HERO Act is to have this written airborne infectious disease plan available and ready to be activated at any time. And of course, part of that requirement is to update it based on, the applicable CDC, New York Department of Health guidance at the time, whatever that airborne infectious disease may be. Hopefully, we never have to deal with this again, but it is a reality. Obviously, we're living through it right now, and it could happen again in the future. So New York State is really covering their bases, not just with COVID-19, but any and all airborne infectious diseases in the future. Section 2 of the HERO Act, this is the final section that we're going to be talking about of the HERO Act. That requires private employers with 10 or more employees, that's statewide. So if you have 10 or more employees statewide, you need to allow and permit employees to establish a joint employer-employee workplace safety committee composed of both employee and employer designees. The effective date of that was November 1st, 2021. And you do need to have at least 2/3 of that workplace safety committee be composed of non-supervisory employees. So the key language here is you need to allow or permit employees to establish a joint employer workplace safety committee. You don't have a requirement to do so. So you as the employer aren't obligated to create one of these workplace safety committees. You just need to allow employees to establish one if they so choose. So there was a lot of questions about, well, how do we manage this employer workplace safety committee? There wasn't a lot of detail. New York Department of Labor only issued guidance on Section 1 of the HERO Act, and there was very scant information about how to comply with Section 2. So just recently, a proposed rule was issued regarding the workplace safety committee requirements. It was issued just a few weeks ago, December 22nd, 2021, and it outlines some of those answers, I guess you could say, for the questions that employers had about, well, when do we need to establish one? What does it need to look like? And what are we as an employer obligated to do under the Act? So a committee can be established by following a written request for recognition by at least 2 non-supervisory employees who work at the worksite. And bear in mind, again, this is just a proposed rule, so it's not currently in effect, but it is anticipated that this will go through sometime in late February. That's kind of the deadline that we're working with. There's a public hearing coming up. I think it's the first week of February. And it's anticipated that there will be a formal rule issued shortly thereafter. But what happens if you receive one of these written requests from at least 2 non-supervisory employees? You need to respond within reasonable promptness. And then within 5 days after you recognize the committee, you need to notify all employees at the work site of that recognition and of the creation of this employer-employee workplace safety committee. And again, what does it need to look like? Who needs to be on it? Well, they outline some specific requirements as it relates to that as well. So committees would be comprised of at least 2 non-supervisory employees. That one was a given. And at least 1 employer representative. So it can't exceed 12 members or 1/3 of the total number of employees at each work site, whichever is fewer. And then work sites with fewer than 10 employees, they need to have exactly 3 representatives. And then when we talk about, well, what does this workplace safety committee do? How often do they need to meet? Do we need to pay them? Do they need training? What exactly is required as it relates to that? So the proposed rule provides that workplace safety committee meetings can be conducted at least once per quarter, and it's going to be no longer than 2 hours per meeting, and that does need to be paid. So paid employees that are participating in those workplace safety committee meetings, those members that are part of the committee, they must be paid for their time and for their attendance at those meetings. You also may provide official training for members, provided that the training doesn't exceed 4 hours in a calendar year. And you also need to pay employees for the time that they spend attending such training, up to 4 hours, of course. And then finally, what are your obligations under Section 2 as an employer? So we know what the committee will likely look like, what it will be composed of, to the extent that, right, 2 non-supervisory employees request to create one. So you as an employer are obligated to respond in writing to any concerns raised by the committee or one of its members within a reasonable time period, respond to requests for policies or reports that relate to the duties of the committee within a reasonable time period, provide notice when practicable to the workplace safety committee and its members ahead of any visit at the work site by a government agency enforcing safety and health standards. So for example, OSHA, right? And then you need to refrain from interfering with the performance of the duties of the workplace safety committee or its members. And their duties obviously are limited to workplace safety. And as I mentioned, the public hearing on the proposed rule is going to be held February 9th, 2022, and New York Department of Labor is still accepting comments on that. So if you're interested in getting some more details on what that proposed rule looks like, please feel free to reach out, and I can send that information to you. Be happy to chat about it. But that's the timeline, like I said, that we're looking at. February 9th will be the public hearing, and then it's anticipated that there will be a final rule sometime shortly thereafter, perhaps late February, early March. What are the civil penalties for non-compliance with the New York State HERO Act? Well, they can be pretty steep. Employers can be fined up to $50 per day for failure to adopt the safety plan, and then anywhere from $1,000 and up to $10,000 for failure to abide by their safety plan. The fines may be increased over time if the commissioner determines that an employer has violated the act in the preceding 6 years. So there we're talking about some repeat exposure. And the HERO Act also provides employees the opportunity to pursue a private right of action for injunctive relief and attorney's fees if they are successful. But there were some recent amendments when the HERO Act was created, right? The governor did kind of pencil in some amendments and some directions to the legislator to kind of ease the burden on employers. And one of those was employees cannot file a lawsuit without notice to the employer of the alleged violation and a 30-day opportunity to cure it. And the only way to get around that requirement is if you as an employer outright refuse the employee's request to cure the violation. Also, one other item that was included in those amendments is employers can recover attorney's fees and costs of defense if the alleged violation of the law is determined to be frivolous. And it's also worth noting that there's a 6-month statute of limitations for any party to bring a legal claim under the New York State HERO Act. All right, and the last slide here, this is really just a quick update on the New York State mask mandate, because there was some recent updates just a few weeks ago. So in December, I believe it was mid-December, the New York governor issued a mandate requiring that masks be worn in all indoor public places unless the business or venue requires proof of vaccination for entry. So this was part of the Winter Surge Plan 2.0 that the state was putting out. The mandate was actually scheduled to expire on January 15th, but it was recently extended for an additional 2 weeks through February 1st, 2022. So the big question that we get is, well, what is indoor workplaces, indoor public places, I should say? Does that apply to me as a private employer? So indoor workplaces is really defined broadly to include any indoor space that is not a private residence. So it does apply to pretty much every employer in the state, right? And when we're talking about indoor workplaces or indoor public places, they're not interpreting that public places, meaning where members of the public can go. It's really any indoor workplace, an indoor space that is not a private residence. So it applies specifically to offices, manufacturing facilities, pretty much everywhere in New York State. And a lot of times we get questions about, well, is there any conflict with the mask mandate and the New York HERO Act? No, there's no conflict there. All employers that are subject to the New York HERO Act, right, are also subject to the mask mandate, and they're required and obligated to comply with both of them. And then the final note here is businesses cannot mix and match their mask policy here. A business needs to choose whether it's going to implement a full course vaccine requirement or a mask requirement. So, right, if you as an employer have a mandatory vaccination policy, technically those employees of yours, if they're all vaccinated, they can go without a mask. But you can't implement a policy where you allow vaccinated employees to not wear a mask and unvaccinated employees are required to wear a mask. It needs to be one or the other. So if you have employees that are unvaccinated in your workplace and masks are required, they're required of everyone, regardless of their vaccination status. You need to follow that policy in its entirety throughout the facility at all times of the day. So that brings us to the end of the presentation here on the New York City private vaccine mandate, the HERO Act, and the update on the New York State current mask mandate. We do bring your attention here to our blogs, the OSHA Defense Report, where we're updating on a weekly basis on all things OSHA related, and certainly right now a lot of COVID-19 issues, updates on the Supreme Court litigation and OSHA's ETS, CMS rule, and everything else. The Employer Defense Report, we're doing the same thing. And of course, we have an MSHA Defense Report on all things MSHA related. And specifically, we have a COVID-19 task force with a resource page where you can get updates on all this information. We're pretty much updating this on a daily basis, almost frequently anyway, that we're updating this in real time as news comes in. So feel free to take a look at that and join our blogs where you'll get updates in real time. And then finally, we have our 2022 Labor and Employment webinar series. We also have a OSHA webinar series where we're covering a host of different topics, labor and employment and OSHA related, throughout the year. So you can sign up for updates. And now we can turn to some of the questions that we might have in the chat. And if you have any questions that are just popping in your mind, feel free to type them in now. And if anything comes up later, Feel free to reach out to me at my email here below, ddeacon@conmosyl.com, or I can be reached directly by phone, 202-909-2738. All right, so I'm going to turn to the chat here and go through some of these questions. So for the mix, we have a question about the mix and match piece about the New York State mask mandate right now. Can restaurants ask employees and patrons to wear masks despite not being fully vaccinated or not? I think that may have gotten cut off a little bit, but you can implement a mandatory mask policy regardless of their vaccination status, yes. Being that New York City requires all in-person staff to be vaccinated, can this be used to negate the state mask mandate? Not necessarily. There are certainly a lot of people that are not vaccinated at this time, given that the New York City vaccine mandate just went into effect. What are we talking about, 3 weeks ago now, and a lot of employers are just having trouble coming up to speed with that. I wouldn't say de facto that you can negate or ignore the state mask mandate at this time. And certainly if you have a large swath of your employees that are receiving or have pending reasonable accommodation requests out there, it's best to make sure that you're complying with that state mask mandate, at least for the time being. Can employers require non-vaccinated employees to wear N95 masks and others to wear any other type of mask as long as it's provided? I think that would be acceptable, yes. If you are providing employees the option, I wouldn't say requiring non-vaccinated employees to wear an N95 would be the best course of action, because then you're getting into OSHA's respiratory protection program and issues related to that, where you'd be required to maintain a written respiratory protection program, conduct fit testing and medical evaluations. You really don't want to get yourself into those issues if you don't have to, but you can certainly allow non-vaccinated employees to wear N95s in the workplace if they so choose, but it should be done on a voluntary basis to make sure that you're avoiding some of those more rigorous requirements under OSHA's respiratory protection standard, because that might create more problems for you than you really need to deal with. All right, and we have one final question about the applicability of, it looks like a question about a food prep kitchen taking online orders and using a courier to deliver. If they don't, I mean, if it is a restaurant that is covered, and this is really a question about the applicability of the New York City private vaccine mandate, or whether this entity is covered under Executive Order 317. I'd recommend taking a closer look at Executive Order 317 to determine whether this food prep kitchen is considered a restaurant. In all likelihood it is, and it would be covered under Executive Order 317, and you'd be required to comply with those requirements. Oh, okay, one more question. Can you indicate specifically the order restaurant owners should be complying with? If not, yes. Okay, so that is in Executive Order 317. There's some additional requirements under Executive Order 317 for restaurant owners, gym owners, and a few other covered entities under Executive Order 317. For instance, you need to have a written plan. Again, all New York employers need to have a written plan under the New York State HERO Act anyway. So this really shouldn't be too much of an issue, but there's a couple additional requirements under Executive Order 317 as well, including the requirement that there be that employees have 2 vaccine doses completed already. All right, one final question about the City Council not passing legislation and issues. This was issued by the New York City private vaccine mandate was issued by the Commissioner of Health as an order, which is entirely within their jurisdiction. They've been doing that the entire time. To the extent that there is any concern about the City Council needing to pass legislation to implement this, I'm not 100% sure off the top of my head whether there's any legal issues with how this order was implemented, but from my understanding, it's entirely within their right to do so. And to the extent that there was an issue, I think a legal challenge would have been filed to that effect, and there hasn't been, right? All right. Well, with that being said, that concludes our presentation. And if anyone has any final questions, feel free to reach out to me. Again, my contact information is on the screen here. Email ddeacon@conmaciel.com, and I'd be happy to follow up with you after the presentation. So thanks everyone for a really engaging conversation here, and I look forward to speaking to you all again sometime soon.